Hi, welcome back to the podcast HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Kill. Sam, morning.
Good morning. How are you, Mike?
Fine, thanks. How are you?
Doing well. Fantastic.
Okay, so today, Sam, we're going to discuss something that I recently published a fact sheet on. It is a really hot topic, trending issue in California HOAs, and not just California, but HOAs all over the country, to be honest. And it's becoming more and more important because more and more HOAs are adopting this technology that we're going to talk about today. I'm going to put a link in the description to the fact sheet that kind of mirrors this episode, but we're going to go into a little more detail in this episode than I did in the fact sheet. But the fact sheet, because this is so statutorily heavy, the fact sheet is at least a written record of the different statutes and how they interplay with each other. And so it's kind of important. So you might want to take a look at that anyway. So I'll put the link in the description. But what we're talking about today is HOA use of auto license plate reader systems, cameras, otherwise routinely called flock cameras. And as we'll talk about very briefly in the show, that's just because the company that seems to be the massive industry leaders, they're the ones that are called Flock. What's their, I think Flock Data or
Flock Data. I think they're based out of Atlanta.
Yeah, based out of Atlanta.
Yeah.
And it's the use of ALPR cameras, auto license plate readers, have become synonymous with Flock. And so, it's kind of a generic now, like Kleenex and tissue.
Or ring cameras.
Exactly. Same thing. Same exact thing. So anyway, we're going to talk about what are Flock ALPR cameras, what the law demands of HOAs that run them. And let me be clear today. There is a huge use of these cameras by law enforcement, both federal and state. We are not going to talk about that at all. That's not what this is about. We are speaking about flock cameras in the context of HOAs in California, because that's what this podcast is about. So law enforcement use, not a part of this show, okay? But we're going to cover what the law demands of HOAs that utilize the technology, that have those cameras installed in their communities, and what homeowners can do if an HOA or director or manager misuses the data, okay? Just understand that there's, in addition to the law enforcement part that we're not going to talk about today, there is also a privacy issue related to a unique facet or aspect of this technology that very easily allows the sharing of this technology between the HOA and any other user in the Flock system. And I'm not going to talk about that because I'm going to do an actual separate fact sheet on that angle alone. And we will do another episode purely on that angle at some time in the next month or so. So I don't want to spoil the kitty today. So I'm going to try to avoid that today. Okay. So let's get into it. What's a flock camera and what does it capture? The company is called Flock Safety. They're based in Atlanta, as you just said, and they make these ALPR cameras, okay, auto license plate readers, okay? Talk to me about basically what an ALPR camera is.
Well, basically, these are cameras that are relatively inexpensive. They are typically within the context of an HOA. They're positioned at entrances, mostly, gates, the private streets within the association oftentimes. Yeah,
entrances and exits of
exactly.
HOA. It doesn't have to be gates, by the way.
I mean, in gated communities, that would be the case, right?
Yeah.
And so what they do is they basically zoom in. They have the capacity to zoom in on license plates and get a full read and log entries and exits.
A very clear picture of it, right? And the technology, it's not just, and I've done podcast episode and we've done, I've done some fact sheets on the use of HOA's use of security cameras in common areas. I'll put a link or two in the description with respect to those fact sheets and or episodes as well. But we're not talking about that. This is a completely different set of laws and a different situation and different technology. This is like an uber super camera, but it's designed specifically for license plates and tracking movement. Which is different than just the typical camera that a lot of us have, or that a lot of HOAs might have in common areas, okay? They capture every single vehicle that comes in, front and back, and it also obviously logs date, time of day, stuff like that, okay? So if anybody any HOA that is utilizing this technology, it is tracking everybody that comes in and out of the community, or drives, depending if they have them in the middle of the community too, drives through the community.
And by the way, they tend to be wireless, solar powered, and the tracking and storage is in the cloud. Or
yes. It's not. There's no wires and there's no batteries to be changed or plugins. Right.
Exactly.
Bottom line. Well, here's the bottom line with why this is a big issue. Tens of thousands of HOAs in this state are using currently ALPR cameras. We're going to refer to that just as flock cameras. They probably are, but they might not be. But I'm just going to call them flock cameras generically. And so throughout the country, they are just booming.
Oh, yeah.
Okay, so there's that. All right, now, the Davis-Sterling Act is silent on the use of flock cameras. And I can only guess, but I think it's a good guess, that the reason for that is Davis-Sterling Act very much predated the invention of the technology. Now, that doesn't mean the Davis-Sterling Act couldn't have been amended more recently to address it, but it doesn't really matter because the Davis-Sterling Act, as people that listen to our show know, is located in the Civil Code. And the flock camera laws that we're going to talk about in a minute are located in the Civil Code. It's just not within the Davis-Sterling Act part of the Civil Code, which doesn't really matter, okay? But the statute that we're talking about is Civil Code 1798.90. 0.5 et sec. Et sec means, and all the ones that are, 1798.90.51 or 52, 53, et cetera. So anything from 0.5 onward, all the way through the end, they're all together. That's the flock statutes or the ALPR statutes. Again, flock to use it generically, okay? In 2015, this is when these statutes went into effect. It was because of SB 34.
Exactly.
And so that's when this law came into effect, 2015, so 11 years ago, okay? And SB 34 was codified as the statute I just referenced, 1798.90.5 et sec, okay? And that group of code sections defined a person as an individual or a corporation or an LLC or an organization or an association. Anything. Basically, anybody that uses the technology is a person within the meaning of the code.
Right.
Now, it just so happens a lot of HOAs are typically corporations, so obviously they fall right within that.
Absolutely.
Okay? When your HOA is operating this technology, they are acting, they're wearing a hat or acting within the meaning of the statute as what the statute defines as an operator.
Absolutely.
When that same HOA then accesses the data that was captured by the camera, they switch hats
End user.
And they're becoming an end user. Again, HOAs wear both hats. It wouldn't do any good to have the cameras and have everything recorded but not be able to access the data.
Right.
That defeats the purpose. So every HOA that utilizes a flock camera is both an end user and an operator as those terms are defined in 1798.90.5C and 0.5A.
Right.
Okay. Now, the reason that's important is that same law, the two laws that I just mentioned, well, actually, 0.51 and 0.53, specifically list out a long list of legal duties or obligations that operators and end users have to follow.
Yeah.
So in order to know, okay, if I'm wearing the hat as an operator, what are my obligations? You got to know what an operator is, which is why I cited the statute here, okay? So HOAs have a whole bunch of duties and obligations just by saying, okay, we're using these cameras. Now they have to follow a bunch of stuff. That's what we're going to talk about next. And you're going to find these duties listed in and I don't want to just keep repeating 1798.50 point something, right? So I'm going to say, if I just say 0.52 or 0.53, you know what I mean, okay? So 51 and 52 require flock operators to, actually, I'll start with users, okay?
Okay.
To do a bunch of things, okay? Now, I'm going to frequently look down my list because I don't want to miss any. I can name 10 of them off the top of my head, but I don't want to miss any, and I want to make sure I include some nuances. So I might be looking down more than usual, but that's because I just want to make sure I say it. Obviously, because of the nature of this data, there's a lot of privacy issues, and we'll get into that, right? So they have to maintain reasonable security and safeguards, operational, administrative, technical, physical, protection, all this stuff. And what does that mean? Well, here's one requirement. They have to adopt a written what?
Privacy policy.
A privacy policy and a
user
usage.
side, user policy.
A usage policy
Exactly.
and a privacy policy.
Correct.
Okay? That is available to everyone.
Correct.
It has to be posted conspicuously on any HOA-controlled website. So there's requirement number one. If your HOA is utilizing flock cameras, then it must have a website that's controlled by it that contains their current written usage and privacy policies regarding the use of the flock cameras and the data that it produces. If your HOA is using flock cameras and they don't have an HOA-controlled website, they're in violation of the law. You know that right away, okay? Those usage policies have to include a lot of things. Let's talk about what they have to include. They have to include what is the authorized purpose that this HOA is decided to use these flock cameras for. They have to state, here's why we have them, here's what we're going to use them for.
Right.
They have to tell you why they're using them and what they're going to use the data for, okay? They have to identify by name anyone who has access to the data.
Right.
So let's say it's all the directors and a manager,
Right.
then those directors need to be named and the manager needs to be named. And if there's an election and a new director comes on and somebody goes off, they have to update the policies. Okay? This is a living document kind of thing, right? It has to state, because this data cannot be stored indefinitely, it has to state what the retention period is going to be.
Absolutely.
Okay? Specifically state it. It has to describe its error correction measures that are currently in place. Okay? It has to spell out whether or not it allows, whether or not it has any restrictions on transferring, selling, or giving the data away.
That's a big one.
That goes into the
Privacy.
thing we're not going to talk about today, yes, but also the law enforcement thing we're not going to talk about. The funny thing is, and I'll just give a little taste, there's two ways that this can be abused, and most HOAs don't even know that. Number one, it could be within their policy to just, we're going to share it with law enforcement, and a lot of HOAs do that, and that's problematic for me. But more importantly, even if they think that their policy says they can't do that, you got to look at the contract that they have with the company.
Oh, yeah.
Because the contract might have a kind of an opt-in, opt-out provision that they didn't even notice that says, oh, we have a right to go in and grab your data and give it to law enforcement. Even if the HOA has no knowledge of it, they better be aware of whether that contract says that. And we'll talk about your right to that contract later, okay? This policy has to keep or the HOA has to keep a running and accurate access log. Who logged in at a specific date and time, because everybody should have their own login, what their query was, who they were looking up, like what license plate they were looking up.
Right.
So what the query was, and the purpose of the query.
Yeah.
If they don't maintain all that data, they are in violation of the law. They have to name somebody. It can be the manager, a board member, but somebody has to be the custodian or the person most responsible for compliance of these things we're talking about, okay? And it has to state, we have a policy of automatic system audits and describe kind of what those audit systems are. What is their policy of audits? Okay? These are duties. They are not suggestions, right? They're legal requirements. So here's the real world. In our experience with HOAs that utilize this technology, tell me about whether or not the vast majority, in our opinion, because we don't have precise numbers, we're only going by our personal knowledge and what we've seen in real life. What percentage of HOAs do you think actually comply with all of the obligations we just talked about?
Well, as far as percentage, I'm not sure, but very few. And the overwhelming majority of
Give
homeowners,
it a percentage.
Let's just say
Under what?
I would say under 25%.
Oh, God, you're nice. I'm saying under 10%.
I'd buy that.
Okay.
I'd absolutely would. And what's even more troubling is the overwhelming majority of homeowners have no idea, and they simply acquiesce. If they see these cameras, they're like, "Oh, well, it must be for a benevolent purpose to prevent crime or other malfeasance, perhaps." And so they think nothing of it.
Right. In fact, I'm gonna be honest with this. If it weren't for what I do for a living or what we do for a living, but I'm speaking about me right now. If it weren't for what I do for a living, I would not know that there's any difference between a flock camera and and its capabilities with data and everything and its data sharing, and a regular security camera.
Right.
In fact, I would look at that solar-powered thing that's sitting up there or down there, wherever it's positioned, but I would look at that as just kind of a weird, more expensive kind of camera than the one I use in my home, let's say.
Yeah.
I have cameras all over our property.
Right.
Okay. I wouldn't know that it was something different.
Like CCTV or the security camera.
Yeah, I have really good security cameras. I can look at my phone and I can look at all the different zones right now if I want. I can look at my backyard, my side yard, the other side yard, the front door. I can look at everything. I can record, I can enlarge, I can zoom, I can do anything I want. I can take snapshots. I would just think it's the same stuff. It's not.
It's not. Yep.
I wouldn't even know that there was a word flock. When I would think flock is talking about a bunch of birds.
Right.
Okay. So in my experience, and again, he was very generous, so 25%, but he wouldn't be surprised with mine. I think the number of HOAs that comply is under 10%.
Yeah.
Because these they are dramatically detailed set of obligations, and they're involved. Mm-hmm. And these are lay people, volunteers, and I just don't think that they know anything.
And many of them will never raise the issue with their legal counsel if they even have one.
In fact, I don't know if I mentioned this, and I don't know if I was going to mention this later or not, to be honest. I can't remember if I don't remember. No, I shouldn't say that. I'm not sure if I would have remembered to say this, so I'll say it now. The statute also requires anybody that's going to be accessing or using this data has to have some training. Mm. Okay? Yeah. I don't think that's ever happened. Okay? In most cases, I would say that the vast majority of HOAs abide by less than half. It's not that they're missing one or two of these. No, multiples of these. They just don't do it. It's not even on the radar.
Right.
That's the danger of this technology. The law says one thing, in HOAs in real life, it's not happening. And the reason that matters is when we'll talk about later, the very weak, relatively weak teeth to this statute.
That is a problem. Mm-hmm.
So now let's talk about basically what the California Constitution, what the California Constitution gives homeowners, because we just talked about the statute, the flock statute, or the ALPR statute, but there's a second avenue of protection for people, and that's just under California's robust privacy laws that are set forth in our California Constitution, Article 1, Section 1. So what does that give us? Okay, obviously, Article 1, Section 1, as I just said, is the privacy policy. Kind of sets forth California's view of the privacy that everybody in California has a right to enjoy. Okay, and so let's talk about because courts, as we talked about in our security cameras episode, because the privacy issue is very relevant, courts employ balancing tests. They look at the relative harm or the relative invasion or intrusion versus the purpose behind it or the results, right? And whether or not there's an uneven balance.
Balancing of harms, yeah.
Right. So as an example of that, in your mind, talk to me about one photo of a particular car coming in or out on a given moment. Is that really an intrusion?
Yeah, on the balancing, I mean, one single incident or instance is rather negligible or nominal. But in the aggregate, if you are tracking, logging, the
over time,
going ins over a course of time, that can really frame, I guess, cumulatively.
And I'll talk about that separately, so don't jump into that. But it can cumulatively frame.
Well, that's going to be a much higher threshold.
Picture. That's right.
Exactly.
Right.
Yeah.
Oh, single use is not really an intrusion. Okay. After all, your license plate is on your car. Everybody on the road, pedestrians and drivers alike, can see your license plate and write it down or take a picture of it if they want. It's not private in and of itself at all. It's just not. But if your license plate is being recorded over an aggregate over a period of weeks, months, okay? And you can develop, especially with AI, a timeline and a detailed record of you as an individual, whether or not your name's attached to it or not, it's irrelevant. This license plate, this car.
Could be a guest, a visitor.
Or a guest.
Yeah.
It implicates constitutional rights of privacy for the following reasons, I guess. Whoever's monitoring that data can now get a very detailed picture of, for example, when you leave for work, when you typically come back. how many times a day you leave your house, how long you're typically gone, who comes to visit you, how often they come to visit you, how long they stay when they come to visit you.
Right.
How long, in other words, does your house typically sit empty?
Mm-hmm.
If there's multiple drivers in your home, do you guys leave? Is there times when you all are gone? And if so, typically how long? You can develop a very detailed picture. And when you're using AI to aggregate data, it can give information that you would never have imagined.
Right.
That's when it starts to really implicate constitutional privacy. That's where the problems start, not the one-off, hey, somebody was robbed. Let's take a look at all the cars that came in and left within a given period of time,
right,
so we can track that one thing down. No big deal. No intrusion.
Correct.
But a misuse of that data. And we're going to talk about that. There are story after story after story of a misuse of that data.
Or pretextual use.
Exactly.
Right? Yeah.
Which is, when it's wrongfully used, always the case.
Right. Yeah.
Right. So I guess we'll talk about this shortly. I have very strong feelings. It's for that reason that I think you share my strong feelings about the teeth. And we'll get to that at the end, okay? So let's talk about that pretext that you were just mentioned. Let's talk about the director or the manager who misuses data. What do I mean by misuse? Okay. Well, there are stories, and you can Google these yourself. And they happen in California, they happen in other states as well, where you have directors who are watching their ex-wives, let's say, okay?
Yeah.
Or soon-to-be ex-wives. Or they are watching somebody that they're stalking, that there's a woman, let's say, that a particular director who might be sick in the head is stalking and logs in to record data and find out this person's habits.
Yeah.
Okay.
Or a simple pure animus, where you have it out for one of the members or multiple members.
You want to rob a house.
Exactly.
You want to do something and you want to make sure they're not there. So you look at patterns, right? That's kind of how you misuse it. Okay. So let's assume for a minute that the data was misused. Your data was misused. What can a director or manager or whoever was accessing that data, what can they be held liable for? Well, first of all, they can be held personally liable, right?
Right.
The business judgment rule, not protecting you. I will put a link in the description on at least one fact sheet on the business judgment rule and one of our podcast episodes on the business judgment rule. For anybody that's interested in looking at that, I'll put that in the description. But the business judgment rule is out the window. It doesn't even, it's laughable, okay?
And by the way, there's also a nexus in terms of this not being smack dab, directly in terms of the Davis-Sterling Act, but elsewhere in the Civil Code and the California Constitution. So that in itself puts it within the purview of something outside of the Davis-Sterling Act.
That's right.
Yeah.
And here's the thing, and this is 1798.50.54.
Exactly.
What we're going to talk about, what a director or manager, if I say director, I mean manager or anybody accessing it, misusing data, they can be held personally liable for misusing that data. And that misuse can, as we just said a minute ago, can run the gamut of stalking or even logging in to watch somebody's movements because you're curious.
Right.
That's not a proper use.
Or selling it off to someone for commercial gain.
It's even worse.
It's even worse.
That also violates the Davis-Sterling Act, by the way.
Absolutely. Yeah.
A director pulling residents' history for personal reasons, whatever they are, okay? Or even a board member or a manager handing an access code to somebody like a homeowner at large that has no legitimate reason to have it. In other words, I'm on the board. I might have a legitimate reason, but I give my buddy, my neighbor who comes up to me and says, hey, can you give me access? Yeah, I give him a login. That right there is a violation. You can't do that.
Huge. Yeah.
There's no legitimate purpose for that individual to have any access. If an HOA is utilizing this technology, it's for HOA business. Period. End of story. Goodbye.
Right.
Okay. So these people not protected. Okay. So what do you get if you get sued? Or what do you get, the homeowner, if you have to sue the HOA and a manager or director or whoever was misusing data? And this is where I have a big problem.
Yeah.
Okay. Let's talk about what the law says. And let's then talk about why it's a problem. Do you remember you already said it's just, well, you didn't. Tell me about what's the law on.
Well, the key aspects of it, the key facets, and this may not be exhaustive, is that basically the remedies are largely discretionary, first of all.
Completely discretionary.
Right. That said, let's say a wrongfulness is in fact.
Well, what do we mean by that? First, tell me what it means. What does discretionary mean, and compare it to any code section from the Davis-Sterling Act, as an example.
So basically, there's not a parameter that establishes, let's say, an actual statutory fine per se, right? That's mandatory, or parameters in terms of the remedies. It puts it directly in the hands of the adjudicating officer.
Yeah. So in a lot of statutes, most statutes in the Davis-Sterling Act, when we talk about remedies. Let's use a fee shifting statute as an example, attorney's fees to a prevailing party. Most of the laws we talk about in the Davis-Sterling Act they all say shall or must, right? The court shall award the prevailing party attorney's fees. In other words, not may award, because that means the court could also not award, but shall. Okay. This statute is discretionary. It's may. There's no shall at all.
Correct.
Meaning the judge could decide not to impose any damages at all, or to allow attorney's fees to a prevailing party, even if you win the entire case proving misuse of your data. A judge could, doesn't mean that they will, but could decide, I'm not going to award any fees or damages. The only must part of this statute is if the court decides to award actual damages, or what we call the statutory damages, they have to award at least $2,500, which is crap.
Peanuts. Yeah,
it's nothing. $2,500 is nothing. Homeowners aren't going to get out of bed for $2,500. Okay, so because they're going to spend more than that to get a letter out. I mean, in other words, it's ridiculous.
It's a very low floor. Yeah.
Okay, I think it should be $25,000, $30,000 as a minimum liquidated damages, which is what the statute calls it, is liquidated damages. It should be enough to be, wow, we better not do this. Okay, so the fact that it's discretionary is very annoying. The fact that the minimum is so low is very annoying. The fact that attorney's fees, after you go through all the hassle, even if the judge doesn't award any damages, at all, decides not to give you the $2,500 or more, and then decides not to give you your attorney's fees, is ridiculous.
As a matter of public policy, there should be a stronger deterrent and disincentive to the whole thing. Yeah.
Why? Big deal here. Okay, but another aspect of this that just gets me is that the statute even contemplates the imposition of punitive damages by the court if the court finds that punitive damages are warranted. Right. Okay, and that's a finding that courts make in all sorts of cases like fraud and other intentional tort type cases. But here it's, again, completely discretionary, not based on whether the evidence supports punitive damages. It's both. The evidence has to support it, and the judge has to say, and now that the evidence supports it, I'm going to go ahead and give it. It could easily support it, and the judge could say, nah, I'm still not.
Right.
I hate that. Right. That's wrong. This statute it's a great set of statutes to have, and they're important because this kind of technology can be so easily, and has been so easily, abused. But the teeth have to be teeth. Right now, I call them, those fake vampire teeth you wear at Halloween? That's what these are. If somebody clamps down as hard as they can, it might pinch you and hurt and maybe even draw a little bit of blood. That shouldn't be the case. It should be gushing.
Well, there should be a deterrent factor, disincentivizing abuse or misuse. And then the other part of it is also an element of knowledge to the party who's aggrieved or who's been damaged to know what they're getting into if they prosecute it or take it to court. Knowing that you have your rights being adequately addressed and you have the requisite remedies, especially the attorney's fees portion of it.
And that at the end, if you go through the immense expense to do all you're obligated to do, that there will be a light. Right. And you can't know that at the beginning of this case because it's discretionary and the judge makes that decision at the end.
That's a big problem.
After you've spent six figures. To get there because your HOA knows it's an abusive HOA and they're going to fight tooth and nail, let's say. After all that, at the very end, the judge could say, meh, and that's wrong. That is just wrong. I wouldn't take the chance unless I was if I didn't care about the money, sure. But for most people, it's not real. And any statute that is dealing with something this critical, because violations of these privacy laws, again, some of the examples we gave, like the stalking, those are pretty scary factual scenarios.
Oh, yeah.
And the teeth might be non-existent. It's not fair.
Right.
That statute has to change. They have to be must.
Agreed.
Change one word,
Mm-hmm.
must. And maybe increase the minimum, but at least change it to must.
Mm-hmm. Or hopefully Davis Sterling Act eventually picks it up and adds some teeth to it.
Yeah, and says,
Yeah.
all those requirements in those statutes are required here, but prevailing party is entitled to return.
Correct.
And one-way statute is what it should be.
Yeah.
Okay, now let's talk about 5200. Sam and I talk about Civil Code 5200, which is part of the Davis Sterling Act, all the time. We talk about it as a powerful tool for HOAs, or for homeowners living in HOAs.
Correct.
That's and I'll put a link in the description to a one or a couple of fact sheets about 5200 and to an episode that we've done. I'll put it all in the description. You guys can click away at your heart's desire. But we talk all the time about 5200 because in the context of HOA disputes, it's a very powerful tool in the arsenal that homeowners have. But in the case of flock cameras, it does very little.
Yes.
Okay, let's give an example. 5200, I scoured the statute. I was as creative as I could be. None of the categories listed in 5200 remotely cover your right to seek the data that involves you. Like, I want all instances or reportings of my car, my family's car entering or exiting the community. No, it's not covered.
No.
HOA doesn't have to give it to you. Okay. Even if it's just footage about your vehicle. Nope. The HOA could give it to you because it is your data. They could, but they're not obligated to. And the only time this becomes a problem is if you're in a bad HOA that's misusing it, and those HOAs are not going to give it to you, right? So what does 5200 reach, Sam? It reaches one thing.
Yeah. I mean, essentially, and I agree with you. I scoured it too, and absolutely would echo those same points. The one category that you could obtain under 5200 that relates to this issue would be the signed contracts.
Yes.
So this would be with flock
or,
safety.
Or another ALPR category.
Correct.
Right.
Exactly.
So the contract between the HOA and flock, in our example, is something that homeowners have an absolute right to, and they can demand it and get it. Unredacted. Now, that's important because once you have that contract, here's some things you should look for because they better be in there. Because if they're not in there, they're violating some of the earlier statute that we talked about. Some of those requirements have to be in that contract.
Yeah.
Okay. So you get the one thing you can get. You're not getting the data. You're not getting the report. You're not getting the training or the usage logs. You're not getting those either. Should have mentioned that. You're not getting that usage log.
Right.
Remember we talked about that required log? They have to keep it, but they don't have to share it. But you are getting the contract. So what do you look for once you've got a hold of that contract? Look at the retention period. Okay, that better be stated in there because it's it's the software that deletes the data every so often. So that retention period has to be in the contract. How long are they keeping your data? A month, 6 months, a year, 2 years, 5, whatever it is. Okay, and then how does that compare to remember those published privacy and use policies that are mandatory that have to be on a website controlled by the HOA? That retention period has to be mentioned in there. So if there is a retention period in the contract, and there better be, make sure it matches the policy.
Exactly.
If it doesn't, violation. Okay. How many user accounts the HOA has authorized?
Oh, yeah.
And who? Because that's got to be in the contract. Now, if it doesn't name names, it should name all the directors and the manager.
If you have a bunch of third-party, service providers that they can dish it out to.
Or if there's 9 seats, 9 usage, and you've got 5 board members and 1 manager, that's 6. What are the other 3?
Right.
Okay. So that's something that'll pique your interest and should pique your interest. Okay. Whether the contract requires those access logs.
Yeah.
Okay. Which are required by the statute.
Right.
The contract better require it. And any conflict between anything in the contract and any of the 2 policies that are mandatory that we talked about before. If you get wind of any of that, you have pretty good evidence of violation. If there's no policy at all, that's just one more violation, right? So anything you want to add?
I want to add one more thing
concerns?
for our discussion on that contract. Opt-in, opt-outs for the use of those records. For instance, sale to third parties for commercial purposes or,
law enforcement.
Well, law enforcement is a big one, of course. So I would look for that as well. That's a key one.
And we kind of touched on this, but we're not going to go into detail because I'm going to do another show and another fact sheet on this. Is this, when your HOA, if your HOA shares that data with law enforcement, for example, to me, that brings up a lot of, that's the HOA acting as an agent of the government at that point. I don't like that because it's one thing to have these cameras on public streets where you don't necessarily have an expectation of privacy about your car being out on a public street. But we were talking about private streets, controlled and owned by the HOA. And that does normally it would require a warrant of some sort or probable cause. I don't like the fact that a lot of HOAs just hand it over. Right. But the scary thing is there's this opt-in thing also about whether or not your database can be accessed by outside users if you've opted into sharing it with certain.
Right.
Because here's what happens. You have your flock camera and your HOA. And then there might be a government-controlled flock camera a mile away and another one 3 miles away. And if you drive that route, you can put together a string of, okay, this is the route they now take, right? Because your car leaves one, and then within a few minutes enters the next one, and in a few minutes enters the next one. And can be, talk about creating a timeline and a report about, that's very scary to me. And that's what you get when you allow outside users somehow to get access to the database that is supposed to be just your HOA's database. That's a separate issue that we'll do on a separate date. Anything else?
No, I think that's pretty good, yeah.
So 1798.90.5 et sec controls the use of flock cameras in California. And specifically, since we're talking about HOAs, your HOA's use of flock cameras. The statutes, while the statute is very clear about all the obligations that HOAs that use this have in terms of user obligations as well as operational obligations, when those are breached, while personal liability is easy to establish to a wrongdoer, whether or not a homeowner will actually get that in the end is so discretionary that it becomes, in my opinion, problematic.
Yeah.
Okay. So if your HOA is running any of these flock cameras, and they don't have compliant policy, or the policies are inconsistent with what the contract says, or they have some issues laid out, but they don't have all of them, you want to contact us at MBK Chapman, because if your HOA is using this technology, they need to be following the law, because the law isn't even that strong given the lack of teeth.
Yeah.
If you like this episode, please hit the like button. If you haven't already done so, please subscribe to our channel, HOA Hell. If you'd like to leave a question, please do so. Until next time, have a wonderful day.